Hello, I'm Gary Fraley. I'm a California State Bar Certified Bankruptcy Law Specialist in Sacramento, California. Today, I want to spend a minute and talk to you about reaffirmation agreements and what they are. When you have a car, for instance, and you owe money on that car, if you don't make payments, there's two things that can happen. Number one, the lender can repossess the car, take it to an auction, or sell it for a fraction of what you owe on it. Then they have the right to sue you for something called a deficiency balance. Not so good, okay? When you file a bankruptcy, Chapter 7 bankruptcy, the right to sue you dies. It no longer exists. All that is left is their lien on the vehicle. If you don't make the payments, they're entitled to come get the vehicle. It used to be as long as you made the payments, you were just fine. But in 2005, when the credit industry bought and paid for Congress and the presidency, what they did is they rewrote the bankruptcy law, and they didn't do it for your benefit. And one of the things that they did was they said, oh, if you want to keep the vehicle, you must put the electrodes still Frankenstein and bring the right to sue back to life. It's alive. You don't want that, but you don't have a choice. Now, to do that, not only do you have to want to and agree to, but your attorney or judge has to sign off that it's in your best interest and it doesn't impose an undue hardship. Now, a reaffirmation agreement is between 10 and 15 pages long. And basically, it has to be filled out showing the budget, the income, the expenses, how you're going to be able to afford the payment. Now, if you have a payment and you can't afford to make the payment, you're not going to be able to reaffirm. A bankruptcy attorney has to look and say, can you afford it? So when you do your what's called the income and expense schedules, if you have no money left over, the attorney will not sign off on that because it imposes what's called an undue hardship. It then can go to a bankruptcy judge. The judge isn't going to sign off on it either. If you can afford it, but the amount of debt on the car is way higher than the value, then, or if you've got a very high interest rate, then it's not in your best interest to reaffirm that debt. The attorney cannot sign off. The judge will not sign off. Now, what that does is it means, okay, it's up to the creditor whether they want your payments or they want the sheet metal, in this case mostly plastic. In the vast majority of the cases, probably 95% of the time, they want your payments. They really don't want the car because they can't get nearly enough out of the car. They're better off to have you making payments. Now, if you do not reaffirm the debt on the car for whatever reason, and 6 months or a year down the road you can't afford the payments, something's changed in your life, you don't want the car, you can say, here's the car, come get it, I don't want it. And they cannot sue you for the money that they do not get. Now, if you don't insure it and there's an accident, that's a different story. Then you've got a problem. But assuming otherwise, we're not talking about an uninsured accident, you are in better shape in that situation if you don't have a reaffirmation. The safest way is if you qualify to do a reaffirmation agreement, then you do so. I hope this helped you understand the process on keeping vehicles, and I look forward to seeing you in my next video. Thank you and have a good day.